will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. We had a president who kept saying he's charged with protecting the American people, while you can read into the Constitution that he's the commander-in-chief and he is in charge of all of the military, and you can get that, but not from the oath. The oath charges him with protecting the Constitution. We had a little difficulty with swearing in President Obama. I think there was a little nerves at work there. If any of you saw that, they actually screwed it up, and they did it again later that day, which I thought was a good idea. All right, now, those 10 questions were taken from a 100-question test from the United States Immigration and Naturalization test that you have to take to become a United States citizen. There's 100 questions on that test. And some of them are as simple as what are the colors of the flag. Some of them get a little bit more complicated. But it's been my understanding and experience and observation that a lot of people who study to become an American know a lot more about our heritage than those with the birthright. That's what Civication is going to try to take a stab at changing a little bit. There's people out there doing it, but I think we need more of this. Now let's turn to the United States Supreme Court. We have learned that the supreme law of the land is the United States Constitution, so it seems fitting that the supreme law of the land be judged and interpreted by something called the Supreme Court. The duty of the judicial branch is to interpret the laws, or in the words of Chief Justice Marshall, to say what the law is. Article 3 of our Constitution has been interpreted by the Supreme Court to give the judiciary the power to declare acts of the President or Congress unconstitutional. This power is known as the judicial review. The Supreme Court mainly has final appellate jurisdiction. However, it has original jurisdiction in, quote, all cases affecting ambassadors, other public ministers and councils, and those in which the state shall be a party. Article 3 is the shortest and least specific of the articles that define the parameters of the three branches of government. But what is the nature of the judicial power? Article 3 doesn't really say. There was no national judiciary under the Articles of Confederation, so the framers of the Constitution created something new. The essence of the judicial power is to interpret the laws. However, Article 3 makes no mention of judicial review, the court's greatest power. Several of the framers implied the idea of judicial review in their comments at the Constitutional Convention, although it was not specifically debated. But as Alexander Hamilton said, he made clear in Federalist 78, the power of judicial review was anticipated even before the Constitution was ratified. Hamilton said that the judiciary was the least dangerous branch of government because it had neither the legislator's power of taxation nor the executive power of the military. It had neither force nor will, but merely judgment. There are many Americans throughout history who have disagreed with Hamilton, not liking that the power of unelected judges have to overturn decisions of elected officials. This bugs a lot of people, and yet Hamilton further said, even though unelected, the judiciary was the true guardian of the ultimate will of the people, the Constitution. Now you think politics is rough today. This is Aaron Burr. Aaron Burr shot Alexander Hamilton in Weehawken, New Jersey. He died a day later or so of his gun wound. It was pretty rough there. There was some off-the-cuff remarks that Hamilton made at some party, and he was challenged to a duel, and Burr was brought up on murder charges, but they were dismissed eventually. But his political career was pretty much downhill from that point on. The Supreme Court established the power of judicial review for federal judges in a case, a landmark case, one of the first landmark cases, in Marbury versus Madison in 1803. In that case, Chief Justice John Marshall faced the consequences of his own carelessness as Secretary of State under President John Adams. Today, Marshall would have had to recuse himself due to a conflict of interest, but he was able to rule on his own action. Marshall had neglected to deliver several last-minute judicial commissions Adams issued as he was leaving office. The new Secretary of State, James Madison, appointed by Marshall's political and constitutional adversary, Thomas Jefferson, refused to honor some of these last-minute appointments. That left the folks who were being notified of their appointments a little bit frustrated. One of them was William Marbury, who sued under something known then as the Judiciary Act of 1789. He wanted to force Madison to deliver his commission as Justice of the Peace for the District of Columbia. The terms of that act, the Judiciary Act of 1789, altered the original jurisdiction of the Supreme Court and allowed Marbury to go straight to the Supreme Court rather than appealing through the lower courts, but not so fast. Chief Justice Marshall and a unanimous court declared Congress could not amend the original jurisdiction of the Supreme Court as set forth in the Constitution without amending the Constitution. For the first time, an act of Congress was declared unconstitutional by the judiciary. In Marbury, there's Jefferson, there's Marbury, I'm sorry, and for the first time, Chief Justice Marshall wrote, "It's emphatically the province and duty of the judicial department to say what the law is." The Supreme Court did not explicitly declare itself to be the final authority on the meaning of the Constitution until 1958 in Cooper versus Aaron. In that case, the court denied the power of the governor of Arkansas to oppose the court's desegregation decision in Brown versus the Board of Education. This man in the middle there is Orville Eugene Faubus. He was a six-term Democratic governor of Arkansas, serving from 1955 until 1967. He stood against the desegregation of the Little Rock Public Schools, defying a unanimous decision of the United States Supreme Court by ordering the Arkansas National Guard to stop African-American students from attending Little Rock Central High School. President Eisenhower federalized the Arkansas National Guard and took the control of the National Guard away from the governor. The unanimous court said in Cooper that the Marbury decision had established the principle that the federal judiciary is supreme in the exposition of the law of the Constitution. However, let's remember that it is the people who hold the ultimate power on amending the Constitution. And it's a very difficult process, but it can be done. It has been done successfully 27 times. I think it's been attempted another 6 times, but they have not been successfully ratified. Ratification can come in a couple of ways, but the primary way requires 2/3 of both houses and 3/4 of the state legislatures to vote in favor of whatever the amendment is. One of the most notable amendments that has not received 3/4 of the states is the ERA amendment from, I think, 1972 or so, whatever that year is. It's still out there, and if the states that haven't read, I think there's 34 states, and if they get a couple more to do it, it could become an amendment. So it's just laying dormant there. So it is the people who have the final say about the meaning of the Constitution through the power to amendment. Now, the history of the Supreme Court is frequently described in terms of chief justices who have presided over it, of which there have been 17 chief justices and 98 associate justices. In the beginning, during the tenures of Chief Justices Jay, Rutledge, and Ellsworth, from around 1789 to 1801, the court did not have a home of its own and sort of lacked prestige. In fact, the justices rode to you on the circuit. They sort of made house calls. But that changed during the Marshall Court. During the Marshall Court, Chief Justice Marshall had the longest tenure of any Chief Justice. And along with the Marbury decision, the Marshall Court ended the practice of each judge issuing his opinion in a series of individual opinions and began issuing a single majority opinion. The Marshall Court also saw Congress impeach a sitting justice of the Supreme Court, Samuel Chase.